I'm coming to you tonight from the Darug Nation here in the freezing cold. It snowed yesterday. I pay tribute to the elders, past, present and emerging, and I would like to particularly honour the women who've birthed on this land. I'd like to address some of the issues that a recent case in Australia, Imogen, raises. Imogen is the case of a teenaged boy started on puberty blockers without his mother's consent by his father, with whom he now lives. The court hearing was ostensibly to hear arguments for and against the child then progressing to artificial opposite-sex hormones. For a start, of the 10 texts referred to in the judgment, only one is anchored in biology, and there is immediately following it on the list a work rebutting it. There was one brave psychiatrist who acted as a witness in support of the child's right to bodily integrity. From the beginning, you can see that the court is already acting from within a genderist framework by the naming of the case with a girl's name. As the case is addressing the right of girls to opposite-sex hormones and puberty prevention are named with boys' names. It is hard to see this as a level playing field or that judgment has been suspended until all the facts are presented. We could, for instance, just have initial rather than a child's name. We need to understand Gillig competence to understand these cases. Gillig competence, which came to our legal system from the UK, is about Victoria Gillig, who sought a decision preventing teenage girls accessing contraception via GPs. She lost the case, and henceforth the mechanism is named for her. So the principle is that a Gillig competent child is one who has achieved, and I quote, a sufficient understanding and intelligence to enable him or her to understand fully what is proposed. So that's Gillig and West Norfolk Health Authority from 1985 in the UK. And there's other case law in Australia that has developed around the idea of whether or not a child is competent to consent and fully understand what's going to happen to them with surgery or other kinds of treatment. Concerningly to me, many of the minors accessing puberty suppressants are deemed to have Gillig competence, but surely believing oneself to be the opposite sex indicates something quite serious in the psyche, which could disqualify one from the use of Gillig competence. Could an anorexic teen who believes herself to be obese under the umbrella of Gillig competence demand stomach stapling or liposuction? If not, why not? But this is the tricky territory of trans activists simultaneously claiming sex dysphoria is a normal human variation, but also the cause of significant psychological distress. Up front, the judgment in Imogen tells us the court has now authorised what's called stage 2 of treatment, which means the administration of artificial opposite-sex hormones after the suppression of puberty. Everything that I've written tonight is from the judgment. The judge also describes the current guidelines for treating kids with dysphoria as the orthodox middle. There is no mention of watchful waiting by name, simply that the mother's expert witness suggests psychotherapy rather than medication, and that the more extreme path is that which ACOM, the AIDS Council of New South Wales, is supporting, namely informed consent, meaning 16 and 17-year-olds accessing GPs who will prescribe for free without a Medicare card or parental consent. Remember too that hormones are on the pharmaceutical benefit scheme. Girls access them with the ticker box that says testicular disorder. It also strikes me that between Kelvin, a previous important case, and Imogen, the court has moved from saying sex assigned at birth to gender assigned at birth, though of course neither are accurate since sex is observed at birth. But why the shift? From the case Jamie, the courts shifted from viewing stage 1, puberty blockers or suppressant, as therapeutic, to Kelvin, where stage 2, artificial opposite sex hormones, are now considered therapeutic and thus not requiring court intervention to give them to a child. There doesn't really seem to be a pathway for children not to be medically managed, since all roads lead to intervention, whether a Gillig competent child is consenting on their own behalf, a medical practitioner is agreeing, or parents are consenting on behalf of a child not deemed to have Gillig competence. Basically, however, where there is any dispute about the diagnosis, consent or nature of treatment, an application to the court is mandatory, and that's from the Imogen judgment. After these two cases, though, it was clear that if child practitioners and parents agree, no court needs to be involved. What this case does emphasise, however, is that the informed consent model is not to be applied to minors, and there are two particularly cogent points in the judgment on this. The judgment confirms the existing law that it is that any treating medical practitioner seeing an adolescent under the age of 18 is not at liberty to initiate stage 1, 2 or 3 treatment without first ascertaining whether or not the child's parents or legal guardians consent to the proposed treatment. And goes on further to say, if there is a dispute about consent or treatment, a doctor should not administer stage 1, 2 or 3 treatment without court authorisation. In this case though, the mother does not consent and the child is still being given hormones. I don't know how that works. In Imogen, it is clear the teen in question is experiencing a number of significant mental health issues. He was diagnosed with a major depressive illness associated with anxiety and panic, but no suicidal ideation in September 2018. The parents are separated. Both he and his sibling and their mother were receiving psychological care, and he was refusing to go to school and is largely still not attending school. In mid-October of 2018, he went on holidays with his father and new partner, who was then researching gender minorities and their access to medical treatment. Upon his return, the child told his mother he wanted to be a girl, and his mother believes the timing was not coincidental. A few days later, the father sent her a text saying the child had chosen a female name and pronouns. He moved in with the father later in this month, and the mother has not seen him in person since the following month, November 2018. After this, the child was on the road to diagnosis and prescription of blockers, then hormones. While being given 2 milligrams daily of Proginova, the court record states that this is not stage 2, which is curious since artificial opposite-sex hormones are administered in stage 2, beginning with doses of 2 to 4 milligrams of such medications. This product initially, however, was bought online from overseas and being given to the child without the mother's knowledge. The child's case also details significant violence within the family unit directed by the father towards the mother, which the father denies. The younger sibling has also disclosed violence directed towards her, and both mother and younger sibling have indicated the father was violent towards the son. He has never been charged, but the family have all received counselling via victims' support. The younger sibling has significant mental health issues associated with this abuse by the father. We know that children with diagnoses of sex dysphoria usually have comorbidities. They usually have other recognised mental health issues, from eating disorders, another form of dysmorphia of the body. They can be on the autism spectrum, they can have depression or anxiety, they can have trauma from living in households with a violent adult. As John Whitehall observes, it used to be assumed by therapists that a child presenting so was a victim of sexual abuse. I am not for one moment suggesting that this is the case for the child in Imogen. I'm simply commenting about wider issues. We also know that 60% of children who live with an abuser, usually male, have experienced another form of child abuse, such as emotional or sexual abuse or neglect. We know that suppressing puberty does more than sterilise children. It also prevents brain and bone maturation. Are the children whose brains are prevented from normal physiological maturation from the age of 12 or even 10, then psychologically competent to truly understand the range of significant side effects which await them as adults after some years on these drugs? Are they truly told that if they cease at some point to identify as transgender, they will then also need to take congruent artificial sex hormones for the rest of their lives to overcome this early damage? I appreciate the family court is considered a place for children to hold such hearings, but I feel like the more I talk to mothers in this situation, the more parallels I see with men's other abuses of the family court system in general. The Australian Institute of Family Studies research showed in 2017 that abusers commonly exploit the intersections between family law, child protection and criminal legal systems to their advantage. We have lots more research on that, and I'm happy to share that with people. I would like to finish with one short paragraph. We know in Australia that the rate of gender dysphoria, which is really sex dysphoria, is increasing constantly. And this is one child who was given permission by the family court to start hormone treatment. This is from John Whitehall. It's fantastic. He's done amazing research. In Re Alex, which is in 2004, the family court considered whether authority to consent for hormonal treatment should be given to guardians of a 13-year-old natal female identifying as a male. The case was complicated by Alex's Gillig incompetence, depression, perceptual disturbances in which Alex could hear his own voice or the voice of his father, and sense that, as Alex said, somebody can read my mind and the thoughts in my mind. The court was persuaded it was in Alex's best interests to start medicines that would suppress menstruation and to continue with irreversible hormone treatment at 16. I find it extraordinary that doctors deny women access to permanent contraception in the form of surgical options, but are committed to this ideology which insists that adolescents, often with significant mental health issues, are able to agree at 12 that lifelong infertility is acceptable to them. And perhaps some of these lawyers could turn their considerable resources to women's needs in this area. I don't know what's going to happen legally in Australia. I know in the UK some lawyers are now ambulance chasing, looking for clients who've undergone transgender medicine interventions. I don't know what's going to happen here, but thank you very much for being here so we can talk about it.